morning, Your Honors. May it please the Court, my name is Lucas Daniels, and I represent the appellant Joseph Fisher. Mr. Fisher was convicted of interference with the flight crew by the trial court under the statute 49 U.S.C. section 46504. This court should reverse this ruling because there's insufficient evidence to prove that Mr. Fisher, one, interfered with any of the duties of the flight crew, or even lessened those duties, and two, that there's insufficient evidence to show that Mr. Fisher intimidated any of the flight crew members. On the first point of intimidation, intimidation occurs when under the totality of the circumstances, the defendant's conduct and words would place an ordinary, reasonable person in fear.
Counsel, why would an ordinary, reasonable person be put in fear in this situation? I mean, Mr. Fisher got out of the seat 3 times, post 9/11 world, small plane. Why wouldn't an ordinary, reasonable person be put in fear and intimidated?
Rising from one's seat would not necessarily, for any conceivable reason I can think of, constitute a fearful action.
But the seatbelt light was on, Counselor, and by rising from his seat and approaching the cockpit, he was directly disobeying that order of the seatbelt light, was he not? 3 times.
The seatbelt light was on, but in fact, the seatbelt light is not exactly what the conviction is about. It's not about disobeying the rules. And the court's ruling under Pelfrey versus the United States, Pelfrey was convicted for his actions.
Counsel, I understand that it's not necessarily about the seatbelt law, but doesn't that go, we're talking about the totality of the circumstances, wouldn't that go to why the co-pilot might be intimidated? Because he's disobeying orders after being given them 3 times?
He was asked to sit down 3 times, and I would say it is possible that you could feel intimidation even though it was never mentioned by the co-pilot himself, any intimidation at all. He never brings up any sort of...
Co-pilot does say that he was really concerned, though. He was worried.
He said he was concerned about the conditions of the flight and about his duties and how he was performing them, but they were never lessened, nor were, he never brought up Mr. Fisher's conduct as a direct intimidation to him.
How do you say that his duties weren't interfered with when he had to answer these questions multiple times to Mr. Fisher, which caused him to look away from the gauges and not look and maintain the safety of the flight?
Well, interference occurs when the defendant's conduct affects the flight crew's ability to perform any of their tasks. So you're right, any task could be possible interference, but the co-pilot cannot more or less have his cake and eat it too. He does claim that his duty is to communicate with the other passengers on the plane. Hypothetically, if a passenger got sick, was vomiting, it would be up to him to try to remedy that circumstances, and that would drive him away from his duties in the cockpit. And he does say that if he had to leave the cockpit, that would be the interference, that would constitute interference with those duties in the cockpit, which he never did. He never left the cockpit.
So are you saying if someone did get sick and needed his assistance on the plane, that person should be charged with this same crime?
No, I'm not. For the same reason that Mr. Fisher should not be charged with this crime. Because it was just an inquisitive person asking a question, a nervous person, as was stated in the record.
So, Counselor, wouldn't create a slippery slope if we allowed this to happen? Because, I mean, your argument is that Mr. Fisher had, I guess, some type of medical condition of some sort. He's really fidgety. So wouldn't that basically require us to look at every passenger's medical history in order to determine whether or not they violated this law?
I would certainly hope not. And I was not stating that he had a medical condition. He was just nervous, which I'm not sure that nervousness is a medical condition. But I think it is a slippery slope in the opposite direction. If we become a nation that will convict someone, and he's facing up to 20 years in prison for standing up on an airplane, which is very common, if I may point out that people do this all the time while the seatbelt light is on. And if we get to the point of convicting someone for 20 years when there is no real clear evidence that he interfered or intimidated anyone on that flight.
Counselor, you said yourself earlier that it's possible that someone may be intimidated by his behavior. So that, at least for the intimidation prong, seems to me that the average reasonable person may feel intimidated. So what I'm concerned with is the interference, and I just don't understand how, maybe maybe allowing, in this instance, he came up 3 times to ask questions and saying maybe that's not interference. But if every passenger on this 9-passenger flight, instead of just having to respond to this man 3 times, you've now got 27 instances where the co-pilot is getting up, and you're saying that people you ordinarily get up on flights when the seatbelt light is on. So if this court is to rule in your client's favor, are we telling them that it's okay to break that seatbelt light rule and approach the cockpit at any time?
No, not at any time. But I do think it can be appropriate. Again, in the vomiting circumstance, if someone was vomiting and the co-pilot didn't see it right away, or if someone had a severe problem or an injury, or even a simple question of when the flight is going to land, convicting them and putting them away for a certain amount of time for acting on those actions, for getting up out of their seat during that. Don't do that.
Counsel, I understand that he's facing 20 years, but that may not necessarily be a sentence, and that's for the court to decide. But it seems to me that he may be guilty of violating this statute. I don't see how this is not interference. I mean, the examples of vomiting and sickness seem a little bit different than a nervous passenger asking about his luggage.
Well, again, I'll just have to say that the question that is before us today is not necessarily about disobeying the rules. In the Pelfrey case, which I was mentioning, many passengers were disobeying the rules. Many of them were smoking when they were told not to, but they were not convicted under the statute, because the statute does not deal with the disobedience of the rules. It deals with the direct disobedience to a flight crew member.
Okay, so let's talk about the intimidation just for a moment. Mr. Fisher used a lot of profane language, did he not? He said something along the lines of, when are you going to land in this damn plane? And it was directed at the co-pilot, just as we saw in previous cases. So I'm having a hard time understanding how this is any different.
On the levels of profanity, I would say damn is rather low on him, and that was only an alleged saying.
Oh, okay, so this is a profanity meter that you're asking the court to adopt.
Not necessarily, but he was not directing that sort of anger towards the co-pilot, as in the Hicks case, where the profanity was directed directly at the members of the flight crew. He was
I believe there was
saying it about the aircraft.
I believe there was a conviction in Tobacco, and there was no profane language directed toward, Tobacco, this is fucking bullshit, I'm going to fucking smoke if I want to. That wasn't directed at anyone. So how is this any different? Yet we saw a conviction in Tobacco.
Tobacco was convicted under the intimidation when he grabbed the flight attendant. And that was really why they ruled in that. It wasn't necessarily for his words and conduct, even though those strong words can be considered. My time is up, counsel. Thank you very much. I encourage the court to reverse this ruling.
Mr. Daniels, you were very confident. I mean, do you do any trial work at your undergrad institution? Well, you just seem very, very confident. You were very prepared, and I was really impressed with you. What I would have liked to see was a little more deference. Yes, Your Honor, no, Your Honor, so that it doesn't come off as cocky, but you're still being respectful to the court. But I still liked how confident you were, because at the end of the day, you're defending a position. You have a client who's facing a maximum sentence of 20 years in prison, so it's going to be important for you to be strong and assertive, but just walk the fine line of being assertive and arrogant. And the way to do that is by showing a little more deference to the court. But I think you did a fabulous job. I loved how you made that final distinction when I spoke to you or asked you a question about the tobacco case and the profane language that was used in that case, and you quickly made the distinction that, Judge, that was actually decided based on the violence, some physical violence, not the profanity. And I was very impressed with that. I mean, I've asked that question before, and I think you're the first person to actually draw that distinction. And when you're doing these types of cases, in the law in general, depending on which side you're on, you're going to have to be able to make those distinctions. Sometimes you're going to have to be able to make those distinctions quickly, which is what you did. You did a fabulous job.